Hello, my name is Clare Murray and I am managing partner of specialist employment, partnership and professional discipline firm CM Murray. And I'm joined today by my partner Andrew Pavlovic, who is a professional discipline and regulatory specialist. And we're going to talk briefly about the SRA's recently issued guidance on sexual misconduct. Hi, Andrew.
Hello.
Could you just give us an overview as to what this guidance is about and why now?
Yes, so the Me Too movement obviously shone a light on the extent of sexual misconduct occurring in law firms. And following that, the SRA had to deal with hundreds of reports coming into them about either historical or contemporaneous allegations. And we had the Beckwith decision at the end of 2020, where the High Court said that solicitors shouldn't be held as paragons of virtue, and the SRA shouldn't be dogmatic in the way it dealt with these cases and pursued them. And it should only pursue cases where the conduct realistically touched on the solicitor's practice or the standing of the legal profession. So after the Beckwith case, the SRA had to sort of take stock, really, and consider all of these live investigations that they have on. I think they have over 100 currently, and think about this type of cases where the conduct does impact on the solicitor's practice and it does impact on the standing of profession. And that's what this guidance is about. It's trying to set out the type of cases where they will and wouldn't take action.
So I think it's a really interesting document, this guidance. You can see the SRA have really tried to provide clarity on some of the common scenarios that we see in practice arising out of allegations of law firm partner in particular, but wider sort of sexual harassment issues. What are the sort of the type of sexual harassment allegations that they're covering within this guidance?
I think there are three main types of cases. So the first would be sort of sexual harassment occurring in the workplace, and we actually saw a recent example of that. They published a regulatory settlement agreement that they entered into with a partner this week, which involved inappropriate text messages, inappropriate touching in the car on the way back from a client event, and then inappropriate comments when the junior associate went on maternity leave.
Right.
And so that's your sort of typical work case. The second category of case would be criminal cases. So criminal convictions, say for rape, where the conduct hasn't got any connection with the practice per se, but obviously solicitors being convicted of criminal offences damages the reputation of solicitors generally. And then you have the third case, which is the sort of the more difficult sort of Beckwith type case, which is conduct which is non-criminal, or at least not alleged to be criminal, and occurs in an environment which is slightly outside of the work context. So, the drinks in the pub after a work event, for example. And what this guidance talks about and what it tries to give guidance on is when the SRA considers that the conduct is sufficiently proximate to an individual's practice, that they will take action and view it as a regulatory matter.
And what are the types of factors that they are identifying when they're looking at proximity?
So they identified a number of factors. So where the conduct took place, for example, does it take place on practice premises? Does it arise in a practice context? And that context can be wider than just a client event or a training event or a networking event. It can then move on if a couple of colleagues or associates decide to move on to a pub following that event. Although that lessens the proximity to practice, this guidance says it doesn't completely extinguish it. So if, for example, someone went off with a colleague to a pub and there was an allegation, they would probably still say that was sufficiently proximate to practice if it occurred as a sort of follow-up to a work event. There's some interesting comments about consent and alcohol in there. They do say that a consensual sexual relationship between colleagues is something that they wouldn't usually investigate or get involved in. But they also give an example of a consensual relationship which turned sour,
Mm.
and then the more senior person was threatening the junior person with certain consequences if they didn't resurrect the relationship. So although they say they won't investigate purely consensual relationships, there's a clear warning sign there. Then in terms of alcohol, they talk about it being potentially either an aggravating or a mitigating factor.
Yeah, I think we've already discussed that. I find it very difficult to see circumstances in which alcohol can be really a mitigating factor. You know, we see so many circumstances where one or both parties are drunk and can't remember, or it just or misconstrue, etc. I know I struggle to see where it's. I think maybe you think of one example where it has been potentially mitigating, but I think it could be quite dangerous for the SRA to include that, even as a possibility that it might be mitigation.
Yeah, well, I think it's more likely to be considered an aggravating factor, because if someone gets so drunk that they can't remember what they're doing, then the SRA would probably consider them to be a regulatory risk.
Mm.
The cases where it may be mitigating would be, for example, if someone hadn't drunk a substantial amount of alcohol, but perhaps they're on medication and they had a bad reaction, or if they used alcohol as a coping mechanism if they had a particular medical condition such as anxiety. But I think they'll be relatively rare. You know, they do make absolutely crystal clear that alcohol consumption would never be a defense to an allegation. So it's never going to get you off the hook to say, oh, I was drunk.
How might it be taken into account then? If it's not going to be a defense, what impact could it have?
Well, it would be a mitigating effect potentially in relation to sanction.
Right.
So if the SRA is considering, or the tribunal, depending on where the case ends up, what sanction it should apply, then alcohol could be seen as a mitigating factor in those relatively limited circumstances I've set out, and it might be something that convinces the SRA or the tribunal to give a lower sanction than they might otherwise do.
And just interestingly, and just slightly switching track, that there was also a recent document issued by the SRA on sanctions as well. I mean, I don't know if you're able just to briefly summarise the SRA thinking there.
Yes, so we spoke actually last year about their consultation on financial penalties, and in that consultation they said that they did not consider that fines were a suitable sanction for sexual misconduct. And this recent consultation is a follow-up on that, where they published their proposed sanctions guidance, which makes clear, as they proposed, that sexual misconduct would not usually be suitable for a fine unless there are exceptional circumstances. And exceptional circumstances might be one-off incidents where the SRA can be satisfied that the behaviour wouldn't be repeated, but they make clear that where there is that senior-junior, or where there is that power imbalance, it's going to be very unlikely that they will consider that there are any circumstances where exceptional circumstances could be applied in that scenario.
Coming back to the SRA guidance on sexual misconduct, one thing that really struck me was that there's a very strong thread of focus by the SRA on the motivation of the supposed perpetrator or the alleged perpetrator, whereas in an employment tribunal context, that's only one potential aspect. Another is the reasonable perception of the recipient, whether it was reasonable in a subjective objective test for them to perceive it as unwanted conduct of a sexual nature, whether it's gestures or comments or physical interaction. Now, I'm assuming that if this guidance says on the one hand, we regard certain types of behavior, if it's not motivated by sexual, it doesn't have sexual motivation, that we regard that as low-level stuff, that we wouldn't pursue from a regulatory context. If, however, it was then pursued in the employment tribunal, and there was a finding of sexual harassment against the individual alleged perpetrator, that actually that would be a matter where the SRA might take a different view, or they might possibly reopen their conclusions.
Yes, I think it's possible that they would. I think the example that they give in the guidance is someone putting their arm around another person's waist, and how they wouldn't necessarily find that to constitute sexual misconduct. Obviously, if that person made clear that that conduct was unwanted and they did it again, then I think that it would be different. But what they talk about is the sexual nature of the conduct, and the touching, and where the touching took place, and what the intention and motivation was. If the tribunal was to make a finding along those lines, then I think they probably would reopen it. But they have made clear in the context of other guidance that adverse employment tribunal decisions in themselves won't always result in regulatory action. I think in that particular case, it probably would at least lead them to have another look at it.
I mean, as I say, I do think there are a couple of different circumstances that they mention. They also talk about, flirtatious banter between colleagues, or between individuals in a bar who just happen to be colleagues. Well, let's say the Employment Tribunal and the ACAS court might, for example, take a different view on that. But I take your point that it might affect the individual's job. It might affect their, whether or not there's a finding in an employment tribunal, but it might not necessarily affect their whole regulated status. So from a firm's perspective, what are the big takeaways for firms to be aware of arising from this guidance?
Well, this guidance makes reference to the Workplace Environment Guidance and Thematic Review that the SRA published in February, and the need for firms to ingrain a sort of zero tolerance attitude towards sexual misconduct, and to cultivate a speak up culture. The thing that firms need to be aware of is what do their policies say? Are they crystal clear about what is and what isn't acceptable? Has training been provided in relation to those policies?
And is it effective training? I think we need very interactive, kind of illustrative training where it really brings it to life. People understand. And also training about reporting up. I mean, the thing that we see time and time again is that things get mentioned, circumstances get mentioned to individuals, often individual partners, and it's kind of shared by the victim on the basis of you mustn't tell anyone. And then the partner, or even the HR department, feel very limited and restricted by that. And I think they need to understand that when the firm knows, and you have legal and regulatory obligations to escalate this, and you must not overpromise on confidentiality. That's literally, like, if nothing else, that is the clear and consistent theme, the message that we always try and get across is: do not overpromise confidentiality, whether you're HR or whether you're a frontline responder. It's really important, right?
Absolutely, yeah, because the self-reporting requirements in the codes of conduct are obligations. They're not permissive. If you become aware of a potential serious breach of the regulatory arrangements, it needs to be reported promptly to the SRA. So you're right, you can't sort of guarantee confidentiality in those circumstances.
Obviously, if you're the victim, I think the SRA takes a slightly different view on the self-reporting obligation.
Yes, the SRA have said they're happy to accept reports from victims directly, if that would encourage the reporting and avoid, potential embarrassment or difficulties of having to go to another partner or go to someone else within the firm.
And I think they've also indicated, though, that they're not going to bring sort of regulatory action against a victim who doesn't report.
Oh no, yeah, that's something that has arisen in the context of their consultation on treating colleagues fairly and potential introduction of a requirement to speak up. They're not going to punish junior people or victims of the behaviour for failing to speak up. It's more aimed at the senior individuals who know about misconduct and who do nothing to stop it or report it.
I think the other thing we see from the firm's perspective is actually the importance of doing something about it, investigating properly and fairly and in a balanced and supported way. And I don't think anybody's brushing it under the carpet anymore. We see very little evidence of that anymore, certainly in the matters that come to us.
Yeah, I think from the SRA's perspective, if an allegation of misconduct was to be alleged and the SRA investigated and they found out that there'd been a prior complaint that had been made against a partner and it had been hidden or hadn't been properly investigated, then that could have consequences for the firm.
Yeah.
So the importance of taking complaints seriously is very important. Is very important from a regulatory perspective for firms as well.
Okay. So what would be so just to sort of pull it all together, what would be the 2 or 3 big points that you would that you would say would be the main takeaways from all of this?
Yes, I think the main takeaways are to think about your conduct wherever you are. Don't assume that once you're outside the office that you're no longer within the SRA's jurisdiction. I think most people know that from the cases over the last few years, but this guidance is helpful in setting that out. Don't try and rely on alcohol, or you may not be able to rely on consent. These are things that are very difficult in practice and shouldn't ever really be used to justify behaviour, certainly not alcohol. Also, I think just generally, although they have made these comments about flirtatious banter between colleagues, I think that's something you have to be really careful about, because you never know how the other person is going to react. Yes, perhaps if you have a very long-term relationship with someone and you might have a feeling of how they may react to things, it may be okay, but I think you should definitely be erring on the side of caution.
Often it's the back of the taxi, misconstrued, kind of intentions, and that can, have really unexpected and unhelpful consequences. I have to say it's really important that this document, this guidance, isn't just held by HR or by the COLB and the senior management team, because the SRA really tried to be practical. I mean, I would suggest that every partner in law firms reads this document and looks at the scenarios, and there'll be a lot of debate, but debate is good because that's the way that you raise awareness and you help to shape behaviours going forward and reduce risk. Thanks so much, Andrew. That's really interesting. And thanks so much if you've been listening and you've stuck with us to the end. Thanks. We really appreciate it. We hope you've enjoyed it and found it interesting. We this is squarely what we do as a firm, and we're very interested. We have a lot of experience in this area, advising and investigating and training. And if there's anything where you'd like to have an informal chat, please do get in touch with us. In the meantime, we'll share a link to the guidance. And if you'd like any more information, please do feel free to get in touch with Andrew. So thanks again, Andrew. Really appreciate it. And thank you again for watching. If you've enjoyed it, then please do like, share, etc. And thanks again. Take care. Bye.